don't be ashamed or don't be shy to monetize your ideas, your concepts. But remember, it must be reduced in writing. Just having it in a dream alone is not going to earn you any money.
Right.
You must wake up from the dream, okay, write it down, and you must have it in a tangible form. Then it can become a work that can be protected by copyright.
Hello everyone, welcome to LaunchPod, the podcast series where we explore pertinent topics on entrepreneurship in Singapore. LaunchPod is an initiative under Launch, NLB's business information and advisory service for aspiring entrepreneurs, freelancers, and micro-businesses. My name is Jennifer, I'm a librarian from the National Library Board, and I will be your host for today. Today, we are diving into a topic that is as important as it is misunderstood, intellectual property, or IP for short, in the context of the visual arts and creative industry. We'll dive deep into what IP is, why it matters to freelancers in any industry, and how you can protect your work and ideas. Joining me is local creative director, producer, curator, among other things. Let's welcome Jeremiah. Thank you so much for joining me today.
Hello, Jennifer.
Jeremiah, would you like to introduce yourself to the audience?
Yes. Hi, I'm Jeremiah Choy. I'm a trained lawyer and I've been practicing as a creative director, producer, and a curator for the past 30 years.
Wow, that's a very long time.
That's a very long time, yes. So I presently teach law to the musicians at the Yong Siu To Music Conservatory at NUS. And I'm also very active with NTUC as well as the Law Society in outreaching to freelancers, especially in the terms of the law. And I also work very well with the National Arts Council as well.
I see. So great, Jeremiah. Thank you very much for joining us today. So let's start with the basics. So what exactly is intellectual property and why is it so important for our fellow freelancers and creatives?
Well, to simply define it, intellectual property refers to the creations of the mind, the human mind, so to speak. It is basically a creative work, an original expression or a technical solution to a problem, and they become creations of value. All right, so when duly protected, this intellectual property can become valuable as it is. So for the people in the creative industry, our work is mostly creations of our own minds, right? So they are our assets, and therefore it is important that we learn how to protect them and learn how to monetize them. Having an intellectual property means that there are two things that you can do about it. All right, as I said, these are assets of our minds, right? So what's the point of having an asset when you cannot monetize it? And especially for us, intellectual property is important for creative people because it's all here, right? And then if we don't monetize it, we're not making money out of it.
So how do
our bread and butter. So there are two ways of monetizing your intellectual property. One is assignment, and the other one is licensing.
Oh, okay. What's the difference between them?
All right, assignment means you are selling it, meaning that when you created a piece of work, you want to sell it to somebody so that somebody can actually make use of it completely. There's assignment. But licensing means that you are letting that person make use of that piece of work, but you retain ultimate control over it. So like in J.K. Rowling, right? She created the story of Harry Potter, and it is in a novel set. So when people want to make the book into a movie, she can license the movie companies. She still retain the ownership of the characters of Harry Potter, the IP of the story and everything else. Then she can also license it to become a experience like Universal or whatever it is, your game show or the music or whatever it is. So whether she sells it or she licenses it is a different thing altogether, right? Yeah. So that's the two ways of monetizing that intellectual property that you have.
I see. So the difference here is basically just who owns it, right?
Yes,
if you assign it, then you're giving ownership away.
Completely. However, there's such a thing called moral rights. In Singapore, we've just adopted that in our 2021 copyright law.
Oh, wow, that's quite recent.
Yeah. So essentially what moral rights means that even if you buy over what I have, you cannot change my name. So you painted Mona Lisa, means that you cannot then take away Jeremiah Choy or put Leonardo da Vinci or Van Gogh or whoever it is for the painting that you wrote, you paint over it and say you are the new painter or the... So moral rights means that you have the right to retain your name to the product that you have. however, you can what you call contract out of it.
Mm.
Yeah. So let's say, for example, I ask you to go write a book for me.
Yep.
Technically, after you've written the book for me, I cannot erase your name because you own the moral rights. But I can contract you and say, I pay you $1 million.
Right.
Your name is out, and I put my name to it.
I see. That's so interesting.
For people who want to look into greater details of intellectual property, I would recommend that you go to the Intellectual Property IPOS, Intellectual Property Office of Singapore website, www.ipos.gov.sg.
So maybe I'm pretty sure some of the audience shares like my similar viewpoint. Could you share with us maybe like some common misconceptions about IP that you'd like to clear up?
So apart from copyright, the other three intellectual property rights that mostly concerned with creative people or the creative industry would have been patents, trademarks, registered designs. Okay, there are also other IP rights that I wouldn't concern ourselves with today, like plant variety, or geographical indications, things like that. Do you know that you can't call any sparkling wine champagne unless it's from Champagne?
Right.
So
Certain
that
cheeses are like that too, right?
Cheese also. So I just wanted to say highlight on patents. So patents is only when you have an invention and you want to patent it, meaning that you want to prevent other people from using it without your permission. So you need to go and apply, and then you need to get their registration, and it needs to be approved by IPOS, the Registry of Patents in IPOS. All right. So in order for you to get that patent, you need to prove three things. First, it must be new, meaning that it must not have been publicly known anywhere or anyway in the world before. It is new. The second thing, it is an inventive step. Meaning that it must be an improvement over an existing product or existing process as it is. And then the third one is it must have industrial application. Okay, so it must be useful or have some form of practical application. So in order for you to get the patent or register a patent for that, you need to prove these three at the Registry of Patents, and then they will look through it, and then the registrar will give you the patent if you have proven that. Now, for trademark, it's slightly different. Trademark is about symbols or words like your LV, your Prada, your Giordano's. Okay, so basically they are a combination of symbols or words that are registered to represent your company or a product of your company. In order for you to trademark that, you again need to prove three things. First, it must be capable of being represented graphically. Then it must be distinctive and capable of distinguishing that good or services from the other goods or services as it is. And the third one is it must not only be entirely of science, it must be more than that. So I cannot trademark cheap something or beautiful something. It must be more than just descriptive of that. So therefore, the 3 points that are stated must be proven before you can trademark something. And again, you have to go to the Registry of Trademark in IPOS to get it registered. And finally, for registered designs, which is very different. Now, when you have designed something, it must be something that you wanted to, that's unique about it, in the sense that it must have a shape, a configuration or pattern or ornamentation of the product that gives that product a unique appearance. Like for example, a chair that you specially design so that the back of the chair fits with the human
It's
form,
ergonomic,
ergonomic and things like that. And then you can register the design as it is. So copyright is actually protecting any author, meaning the person who created it, as long as you've expressed in a tangible form and it's original. So these are the main differences in that sense. The first three needs to be registered, whereas copyright is automatic protection.
I see.
Yeah.
Actually, speaking of this kind of interesting case study, an interesting example, could you share a couple of famous ones, either good news or bad, perhaps something that can help freelancers learn the do's and don'ts when it comes to safeguarding their IP?
Yeah. Okay, it's a very interesting case that's ongoing for the past 20 over years. Yeah. I mean, for the people who've been around, you've heard of the brand, the famous brand, French brand Lacoste, which is a crocodile facing the right side, and our very own Singapore brand Crocodile with the logo facing the left side, right? So there has been this ongoing dispute because Lacoste was actually established in 1933 and registered in France in 1927. Okay, so and Crocodile band only started in 1947 in Singapore, as it is, right? And Crocodile is left facing and Lacoste is right facing. So basically, when Lacoste came to Singapore in the 50s and the 60s, they tried and tell the Singapore courts that Crocodile cannot exist because Lacoste has been around for the longest time, right? Those days, the intellectual property rights were not so established or not so firmed in that sense. And also, how would a merchant in Singapore know what is happening in France? Because communications at that time wasn't so easy, so convenient, right? So Lacoste couldn't prove that Crocodile Singapore copied Lacoste.
Oh, okay.
Now you can, right? But in the past, when communications are not so easy, no emails, no internet, no nothing, you must have proven that the boss of Crocodile has travelled to France and so, oh, this is a nice logo and therefore I bring it back to Singapore and start my own brand called Crocodile. So in a way, after fighting in court, they came to a very coexisting agreement, all right? So it was good for a short while where they coexisted within the region. And then Lacoste wanted to go into other markets in the Philippines and in India. And so they started this case again because in the coexisting agreement, these two countries were not in it.
Oh.
Yeah. Unfortunately, Lacoste didn't win because the courts in the Philippines and India felt that you already have coexisted and the people who buy Crocodile will never think it is a Lacoste.
Or vice versa.
And vice versa, yeah. So in the end, Lacoste didn't manage to claim so logo of the two markets as it is. Yeah. So another one is if you are into music, you know, when our dear Lady Gaga came out with Born This Way, a lot of people said that it sounded very much like Madonna's Express Yourself.
I see.
Yeah, even though Madonna did not sue Lady Gaga, they kind of have an agreement. To coexist, so to speak. Ultimately, I always think of it in three different buckets, three different categories.
Okay.
First and foremost, you must prove that you're the owner of a work. All right. So as I said, for you to be an owner and claim copyright of a piece of work, you need to prove originality. You need to prove that it was expressed in a tangible form, whether it was written or recorded or drawn or something like that. And remember, it's got nothing to do with creative merit. All right? So at the end of the day, I still need to prove it. And a lot of time in Singapore, there are three ways of proving it. One is that you put your work, write it down, fold it in an envelope or put it in a USB, put it in an envelope, mail it to yourself. Don't open the envelope. And then when somebody challenges it, you can then prove to the court there's a postmark. This is when the idea was already in existence at that time. Right. The second one is you can go to a depository, a lawyer's depository. Some of the lawyers actually have depositories of copyright. You can register with them.
I see.
And the last one is when you can then go before a commissioner for oath and declare. Okay, the thing about it is that when you declare before a commissioner for oath, means that you're saying that it's the truth and nothing but the truth, so to speak. But if you told a lie, you can then be fined or jailed as a result of that. So it's quite serious when you declare that I actually have this thing done in 2014. And you have to prove that it is that. Yeah, that's the first bucket that you have to think about, whether you own the right to it or you can claim right to it.
Okay.
The second bucket that you can look at is infringement. So you have rights and you have an owner. How do you then claim that somebody infringed it? So you have to prove that, oh, how many bars have been copied? It's so familiar that it is therefore an infringement, right? So I always sing this to my class. Okay, my singing is not good, but if I were to say da da da, you won't know what song is it, right?
No.
Da 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 da, roughly. Da 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 da.
Oh,
Home.
I'm not sure. Home. Oh.
Right? So in the first three notes, da da da, you won't be able to say it's home.
Yes.
Da 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 da. Okay, closer to home. But when I go da 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 da, straight away you know it's home.
Right.
So how much of it is not about the quantity that's being copied, it's the quality. How much of it can be identified by other people that it will sound like your work.
Right.
So therefore, there is this infringement that you have to prove to court that the person has actually infringed your work in that. Now, having proven ownership, infringement, we need to have the third bucket. The third bucket is actually what we call damages. Whether you as the owner want to sue the infringer is a whole different criteria altogether. So if I were to copy Madonna's song on Facebook, but would Madonna want to sue me because I'm a nobody and I have no money? So she will then have to activate lawyers in Singapore to sue me and go through this whole process of suing me.
Right.
Unless I am a very rich person,
Right.
then she can get money out of it, right?
It's worth suing.
Unless I'm Lady Gaga lah. It's a different story altogether, right? So whether it is worth suing and worth suing for how much is the damages that we're looking at.
I see.
So sometimes, I'm not saying that you take the risk, but sometimes when you have you want to utilize somebody's work, all right, but you can't because you can't contact the person and get permission from it. You have to show to the court that you have done due diligence in trying to contact the copyright owner and trying to get permission to use the copyright. And in the end, if you infringed it, what happens? Yeah.
What types of creative work are typically protected by IP laws?
There are many, in a way that there are four main categories of work that can be protected by IP laws. Basically, you need to look at literary work, means you write a book, you write lyrics to a song. This literary work category will be protected. The second category is dramatic works. If you've written a script or you've written a dance movement, even if you draw stick drawings and things like that, that can also be copyrighted in that sense. Then there's musical works when you write songs, tunes, compositions in whatever form, pop, jazz, whatever it is, that can be copyrighted as well. And finally, artistic works that includes paintings, drawings, sculptures, engravings, photographs, as well as artistic crafts that is one of its own kind and not mass-produced. So these are the four main categories where you can claim copyright to it. Now, of course, there are secondary rights. And from all this, you can turn it into a film, turn it into a score, sound recordings, turn it into TV or radio broadcasts, cable, or performances, live performances as it is. So these are the categories that you can claim copyright to. Yeah.
Oh, that's actually quite an extensive list of categories.
Yes. And now, because of what expression is, things are beginning to meld, right? So you can be a film that is animated, you know, and then with that, music scores into it and things. So there's a lot of gray areas now. Yeah.
So yeah, I think we talked about a little bit about the new Copyright Act in 2021.
Yes.
So I'm pretty sure that covers, like, you know, if you're contracted by a client to create visual assets, like how much of the IP is owned by me, sort of thing. So yeah, there's the whole thing about licensing or assignment.
Exactly. But again, at the end of the day, right, if you sit in a room and contributions flow freely, I think one has to work in a good faith situation, in that sense, because you build on my idea, I build on your concept, right? And so usually we will agree that at the end of the day, you know, this work is jointly owned or owned in whatever percentage that we all agree to.
Just now you spoke about operating in good faith. I would love to do that. I'm sure everybody would love to do that. But unfortunately, this is real life and not everybody will operate in good faith. So how can I protect myself? How can I protect my work? How can I protect my IP? And what actions can I take if my work has been infringed upon, unfortunately?
Okay, sure. First and foremost, work with people that you trust with. I mean, there are along the way a lot of alarm bells, and if you don't feel comfortable, then be gentlemanly, put it in writing first. All right. So how do you protect yourself as it is basically, no matter what piece of work it is and how much you've contributed, if you've contributed totally, meaning that the graphic idea of yours, okay, that means you've drawn something, is totally yours, then you can own 100% of it.
Right.
But if you drew it and somebody colored it, then you have to agree with the person how much percentage is yours and how much percentage is the person who colored it. So something in writing would be good. Okay, so that's the proving of the ownership as it is. When it's infringement, meaning that just altering your concept alone is not an infringement, right? Again, a lot of ideas flow freely. So it's very difficult when I say, I like my work to be A, B, C, D, E. Then you come in and say, actually, it should be A, B, C, D, F. Skip E.
Right.
Is there an infringement? I don't think so. But the thing about it is that it's very hard to prove at the end of the day how much of the idea A, B, C, D is mine and how much of the idea F is yours.
Yeah.
So it's all about proving in court. Yeah.
So on the other hand, how can I do my due diligence to make sure that I don't step on anyone's toes? I don't infringe on other people's work and IP.
You need to claim ownership of a piece of work. As Singapore is automatic protection. So if you have done it, reduced it in writing or graphically or recording, all you need to do is to put the C with the round thing, the copyright symbol, your name and the year. Okay. But it's only a notice. Once you put that, doesn't mean chop, seal, and confirm is yours. But you're putting the whole world at notice that this piece of work that's written here is mine. But ultimately, if you want to sue somebody for infringement or somebody wants to sue you for infringement, you still have to prove to the court that this is your idea. When was it created, and was there any witnesses to see that you created that? Ultimately, it's that.
I see.
Yeah. So at the end of the day, it's also about your word against my word. So we just need to prove the evidence in court.
But how do I make sure that I do my part? I don't infringe on other people.
See, the word here is due diligence. So basically, due diligence means that if you know that this piece of work that you saw on internet may be belonging to somebody, then you need to contact the person. Then there are what we call collective management organizations, such as Compass, Class, or MRSS in terms of music. You can contact them because they represent people who are members, and therefore you can pay them so that they can pay their members accordingly as well. But if you have done your diligence, meaning that I wanted to use a phrase from your book or a picture of yours, and I've contacted you 3 times and you are not contactable, then I will have to ask myself, do I want to take the risk of still putting it online? Okay, and there are 3 possibilities or exemptions from you needing to get permission. That's what we call fair use. So I can use those information if I can prove that it is for research and study. That's the first fair use. The second fair use would be if it's used for criticism or review. That means I take a portion of your work and then put it online. Now you can go on YouTube and they are singing teachers, right? And then they take Taylor Swift song and then a portion of Taylor Swift performance, and then they explain to people, oh, how come she can hit this note? What did she do that was correct and things like that. That's for criticism and review. I don't need Taylor Swift's permission to put that online. And the third situation is for current news, meaning that you've posted an accident video online and then CNA sees that and they want to make use of that posting. They don't need your permission, even though they will try and contact you, but they don't need your permission to put it in their news because it's for news, current news as it is. So these are the 3 fair uses, which are excuses from getting permission.
Well, protecting IP is definitely crucial, but it's not always very straightforward, isn't it?
It's complicated.
Right.
It's a good thing to have, and it's a good thing to always respect. But it is a very difficult thing to follow through. So
in the process of trying to, protect your IP or trying to respect other people's protection, there might be some challenges faced, especially when someone is not very familiar with IP, which is why hopefully this episode helps to clear some of those things up. But in your opinion, what are some challenges that freelancers might face when it comes to safeguarding their intellectual property? Anything you've heard of or maybe even experienced yourself?
Okay, so in the sense of safeguarding, as I said earlier, intellectual property rights such as patents, trademarks, and registered designs, all you need to do is to go to the registry at IPOS to check whether this has been registered before. Then the infringement is a very clear thing, yes, no, right? Whereas copyright, there's no registry, so it's very hard to find whether it's infringed or not. So at the end of the day, right, how do you protect yourself, as I said, is that did you create that work? Is that work original, and has it been reduced in writing or in a tangible form? If you can do that straight away, you protect yourself by registering it or telling the whole world that you are the owner of that. So once you do that, right, you are able to claim ownership and leave a contact so that people can contact you. Because if you don't leave a contact, if people don't know how to contact you and they use it and they say, I have tried to contact you, then there is due diligence, and then in the end, the damages is very low as it is, right? Yeah.
So if I want to avoid I guess like any infringement from happening, are there any common mistakes that me as a freelancer I should avoid? So like what are some of the best practices that freelancers can adopt when it comes to dealing with IP?
Research, find out whether you're infringing. Anything on the internet is not fair game in that sense that just because it's on the internet, you can just crop, screenshot and then put it in. Unless you can prove it's for study or research or criticism and review or current news. Otherwise, try and find out the main owner.
Right.
However, there are also other sites where you have stock images or stock photos or stock videos, especially when you are a creator, content creator, right? You pay a subscription to that, then all this are already covered.
Right.
So sometimes when you want to create a video, you subscribe to stock music website. All these are already what we call copyright-free music, meaning that these people have been paid by the website to use the music free of charge because you paid a subscription to that.
Right.
So you double check.
Okay.
Unless you want to make use of something that is newly created or not part of this stock images or stock music, then you have to go and look for the copyright owner. Yeah. So it's due diligence at the end of the day. Yeah. You must know your rights. You need to protect yourself, protect your rights. And knowing your rights and protecting your rights is two things. But at the end of the day, whether you want to assert your rights or not, whether you want to sue that person.
That's a choice, right?
That's a choice, yeah. Whether it's too leceh, too expensive, you know, yeah. And at the end of the day, always look at the contract. Contract.
We've actually talked quite a lot about contracts over like the past time that we spent together. So let's talk about contracts. You said that you need to have a contract in like many scenarios. It can be vague, but what does it mean? What does a contract mean to a freelancer? How important is it? Quite important, right? And what should you look out for in a contract to make sure your IP rights are protected? For example, just now you said in like an employer-employee relationship, in your contract, it states that your IP that you create as an employee usually belongs to your employer.
Yeah.
So yeah, if you could explain a little bit more about that, that'd be great.
So essentially, there are two types of contract for our purposes. If you are a freelancer, okay, it is a contract for service. And if it's an employee, it's a contract of service. Okay, so contract for service, meaning that you are working for the company as not as an employee, but as a freelance. It is basically an agreement that you enter voluntarily into between two or more parties, okay, which creates an obligation to do something or not to do something in exchange for something of value, all right, and therefore creating an intention to enter into a legal relationship of rights and duties or mutual obligations. I know it's a very long definition, but essentially for a contract to be valid, you need to have 5 elements. Offer, acceptance, consideration, okay, intention to form a legal relationship, and certain terms and conditions.
I see.
All right. So basically, if you have one of these elements missing, it may just be an agreement, but not a contract.
Right.
So all contracts are agreements, but not all agreements are contracts. So agreement can be valid, okay, whereas a contract is valid and binding, meaning because of the contract, I can then sue or be sued as a result of that.
Right.
Yeah. So in Singapore, one of the things that is very important is that most of the time people want to hire you, but they don't want to give you a contract. All right. So the good news is oral contracts in Singapore are still valid contracts. When it's got matters of the land, meaning that a tenancy agreement or buying or selling a land, you need to have it in writing.
Okay.
But just basically hiring me or selling something, an oral contract is still a valid contract.
Right, that's good.
Unfortunately, at the end of the day, if something goes wrong, it's a matter of proving in court. So at the end of the day, it's really about evidence. And so we can be a little sneaky about it. If somebody doesn't want to give me a contract, how do I reduce whatever we've discussed into evidence? So what you can do is, if you have WhatsApp communications, email communications, you sneak into it and say, hey, hi Jennifer, we spoke just now. You say you asked me to come and perform or come for this interview today.
Right.
It is X number of dollars. It will be happening what day. Can you confirm? And the moment you confirm, that will form evidence of what we've just discussed.
Right, like a paper trail.
In a way, it's a paper trail to certain words. So even though It's not completely in the written form because in order for a contract to happen, it doesn't have to be in a legal language or in very legalized manner, A4 size, typed or whatever. It doesn't have to be. So long as the terms are understood by both parties, there is offer acceptance, there is consideration, there is legal intention to form a relationship, and also there is terms and conditions. So long as I can prove within this email, SMS, WhatsApp exchange between us, even on Telegram or whatever it is, I then can prove to court that there is an essence of a contract, and therefore I can sue you or you can sue me for that.
I see.
Yeah.
I see. Thank you so much for breaking that down for us. I think it's very important as freelancers, as long as you're working with a client, to always have a contract. It doesn't matter whether they're like friends or family. Having a contract helps to protect your rights and helps to protect your client's rights as well. So if you would like to know more about IP contracting, we have actually a lot of resources available here at the National Library Board. You can check out the Liconcian Reference Library, or you can check out NLB's mobile app. We'll be providing a resource list with links in the description. I just want to ask, do you have any like final advice? Just like a nice statement to wrap up the session today.
Yeah, I think it's very important for us in the creative industry. Everything that we do actually is in our minds. It all came from our minds. We're not like craftsmen that we can do a rattan basket or sewing or whatever it is that we can sell the product as it is. A lot of time we are providing creative services.
Right.
So these creative services are actually creations of the mind, which are very valuable in terms of assets, and we must learn how to monetize them. Don't be ashamed or don't be shy to monetize your ideas, your concepts. But remember, it must be reduced in writing. Just having it in a dream alone is not going to earn you any money. You must wake up from the dream, okay, write it down, and you must have it in a tangible form. Then it can become a work that can be protected by copyright as it is, right? So always know your rights, always protect your rights, and at the end of the day, you have a choice whether you want to assert those rights or not. And when in doubt, always seek advice, consult a lawyer or an IP specialist to see whether your rights has been infringed or how to protect your rights as it is.
Thank you so much for being with us today. Thank you for sharing your legal expertise and your advice. I hope this was useful to all of you freelancers out there on protecting your intellectual property and your creative works. Remember, every project that you take on is not just work. It's a reflection of your own branding, your own reputation. It's very important to protect your rights. So speaking of reputation, see you on the next episode where we continue to explore more about contracting and reputation. What are some of the core strategies that might help? Whether you're new to freelancing or looking to elevate your career, this episode offers actionable tips to set yourself apart to grow your freelance business with confidence. Thank you very much, everyone, for joining us on LaunchPod. If you're a freelancer, platform worker, or aspiring entrepreneur, do check out Launch. Launch is NLB's Business Resource Center and Advisory, which connects you to the right resources, spaces, and network. Do sign up for our one-to-one free consultation services with our Launch specialists, participate in our program, and visit the Launch website page. You may scan this QR code or access the link in the description to find out more. Please subscribe and follow the LaunchPod series on NLB's channel on Spotify or YouTube, and share this episode with anyone who you think might need it. And with that, that's come to the end of the episode for today. My name is Jennifer. I'll see you next time. Thank you.